In this first session, we have two speakers. To my right is Daniel Denman, who's the co-director of legal advisors in DEXEU, which I'm sure you know is the Department for Exiting the EU. He's going to lay out the government's approach for us, and very, very thanks for him to coming here and doing this today. And to my left, we have Shona Douglas-Scott, who is the anniversary chair in law at Queen Mary, University of London. Shona is, up to a point, I think, going to respond a little bit to what Daniel says, but she has a few points of her own to make about the major issues involved in legislating for Brexit and how it can and should be done. We will, as always with our conferences, have plenty of time for questions and debate afterwards. So without further ado, Daniel, over to you.
Thank you very much. And it's a great pleasure and privilege to be invited to speak, especially given just how glittering the assembly of people who are speaking to you today is. I certainly agree, first of all, with what you said about how this process has been a learning experience. I've been doing EU law for 20 years or so in government, and I've learned an enormous amount in the last year that I had no idea about. I thought I knew about some of this stuff, and it turns out that actually a huge variety I wasn't aware of. It's a strange position for a civil servant to be in, to emerge blinking into the sunlight like this, especially after quite such a political moment as last night. And so I don't want to get into the politics today. There have been many opportunities yesterday for parliamentarians to debate the bill. There'll be many opportunities to come. And I don't think I have a particular position to contribute to the political debate as such. So if I say anything that sounds politically interesting or sounds as though it's a statement of government policy that's surprising and noteworthy, that's a complete accident, I didn't mean it. And the political position is as declared by my political masters. And I'm departing in no way at all from anything they say. What I want to do is to concentrate on the technicalities and the technical process and to try to explain to you what led us over the last year to produce the bill in the form that it's in. Because it's been an immense technical process. You'll hear from speakers throughout the rest of today about the complexities that we've been grappling with, just what's involved in that process, just how many questions it throws up. And I want to try to lay out for you the kinds of considerations, the kinds of thought processes that led us to come up with the answers that we did. Of course, there's room for discussion and debate about all of these things, about the decisions that were made, the choices that were made, the mechanisms that were chosen. And the value of an event like this, and of course of the parliamentary debate, is that it allows these questions to be discussed, to be thrashed around. We don't claim to have a monopoly on wisdom. Of course, there may be other decisions that could have been taken, other choices that could have been made, technical improvements that can be made to the bill, and that's all part of the process of considering a bill like this. But as I say, what I want to do is to try to explain to you the processes that led us to get to where we are. I think the reason for the bill is very well known. The point of it is to make sure that on exit day, there isn't a void at the heart of the UK statute book. The point of it is to make sure that immediately after exit day, to the extent possible and appropriate, individuals, businesses, everybody can be reasonably aware of what the law is, of what their legal positions is, what their rights and obligations are. That's what it's about. And the bill is a broadly policy-neutral vehicle for allowing that to happen. It tries to put in place the mechanisms and the structures in order to enable that objective to be achieved, subject to the detailed policy decisions that need to be made. Now, I hope I'm not speaking out of turn when I say I think everybody agrees with that broad objective. I'm sure there are all sorts of political views about the principle of Brexit, and I'm sure many strongly held views in this room, but putting that to one side, accepting that it's happening, I think everyone agrees that a bill of this sort is needed in order to achieve that objective. But of course, this principle is much harder to state than it is to apply, as with so many things. And the real difficulty and challenge is in trying to unpack what that principle means and trying to work out how it is that you go about introducing into the UK statute book a set of legal principles, laws that have been applied through the European Communities Act originally and that are now going to have to be domesticated in some way. And this inevitably requires all sorts of decisions to be made. And you can't avoid these decisions, and I'll try to go on to say. And one way or another, you have to get off the fence and decide how you're going to resolve a lot of these technical points. I'm going to try to set out, give a flavour. Obviously, I can't, in the time available to me, deal with every single technical aspect, and the rest of today we'll be looking at all sorts of them. But I want to try and explain how those questions were answered and also how it was that we ended up with these famous powers in the form that they are. So these are the two big questions. One, what is it that's being preserved in UK law and through what mechanism? And two, what delegated powers are needed in order to make it work? So starting with the preservation of EU law in UK law, that wholesale transposition of all of these legal principles and all of the legislation that has come through, if I dare use that word that went down so well with the Supreme Court, through the conduit of the European Communities Act into UK law. How do you go about turning that into a domestic legal system? Some of it is straightforward, some of it isn't, some of it's mind-blowing. The easy part is legislation that's straightforward and self-contained. It's always very treacherous to stray into examples, but I will dare to suggest that one of the examples of the straightforward category would be things like health and safety, working time regulations, and so on. That's a self-contained system. It just works. And so you transpose that into domestic legislation. You maintain its existing transposition into domestic legislation, and pretty much nothing else is needed. That's the simple category. But then you get into the others, which are far more complicated, and when something more needs to be done. Now, as I say, we've discovered from talking about this bill that any seemingly innocuous example that you use turns out not to be. And so we've got this little cottage industry in coming up with hypothetical examples that manage to try and avoid getting us into hot water. So here's my attempt. Imagine an EU regulation that's dealing with the very important and lucrative industry of squirrel racing. Squirrel racing is, of course, a vital part of the economy and people flock to see it. There's an EU regulation which says that anyone who's registered in any member state to be a referee in a squirrel race, that qualification must be recognised anywhere else in the EU. And there's also a rule in that EU regulation that says each member state must notify the Commission of who the approved body is for approving squirrel racing referees. And immediately you have a dilemma when it comes to putting that into domestic law. It's an EU regulation, so it's already part of domestic law through Section 2.1 of the European Communities Act. So the first part of it is simply to maintain that. But then there are these two aspects of it that simply don't work on their face. Something needs to be done. First of all, who do you tell about who the British regulator is for squirrel racing referees? And secondly, more fundamentally, the regulation is based on reciprocity. It's based on being a member of the European Union. It's based on the presumption that things that happen in other member states will be recognised in the UK. And you need to do something with that. There's a policy decision to be made, and I'll come on later on to discuss it. But that's the vast category of legislation, of European legislation that's part of UK law already, where choices need to be made in order to make it work. And I think, so far, that principle is also relatively uncontroversial. It's agreed that when you bring all these things into domestic law, you need to do something in order to smooth off these rough edges. And that is not straightforward because decisions have to be made, and you need a mechanism for making those decisions. I'll come back to that when I talk a bit more about the powers in a second. But just to give a flavour of the complexities, and again you'll hear more about this in due course. Again, this simple proposition that you're trying to preserve this thing in UK law raises a whole host of technical questions. One of them is, what will this thing be? The EU regulation has floated out there as part of EU law perfectly happily, and it's been brought into domestic law through the European Communities Act so that individuals can rely on it in UK courts. It's going to be turned into some sort of domestic beast. It's going to be part of UK law. It's going to be a peculiar looking part of UK law because it has things like recitals and a legal basis that reflect its origin as EU law and reflect in particular in this case the fact that it's intended to be part of the internal market and part of the process of removing barriers between member states. So you have to sort of lasso it and bring it into domestic law in some way. So what is this beast? And again, this is an example of just a technical decision that you have to make. Is it simply secondary legislation or primary legislation of the same kind as any legislation that's already existing, or is it something else? And that's a decision that you can't avoid, and what we've discovered over the last year of considering these things in detail is that there's no straightforward answer, because whatever you turn this into, you need to deal with the implications. And so the solution in the bill is to turn it into a new kind of domestic law, a new thing, and then you specify in the bill precisely what that means in all sorts of respects. And you'll hear later today how that interacts, for example, with the Human Rights Act, how it interacts with normal principles of judicial review. But it's a question that needs to be answered, and we, at a technical level, over the last year, grappled with that sort of question, and this is the answer we came up with for various reasons, which are entirely to do with just having to make these decisions and having to convert it in some way. Another question concerns the right that individuals might have to challenge the validity of that regulation. That can happen at the moment. It happens through the European Court of Justice, and the court has made clear in its case law over many years that it and only it can consider the validity of EU legislation. Is this a task that you transfer to the UK courts? It would be a very peculiar task if they were to be given it, because the question they would be considering is, does this legislation comply with a whole series of principles that are integral to the fact that the regulation is an internal market instrument? It would be very odd if the European Court were to consider whether this regulation properly promoted the objectives of the internal market when it's been turned into something different. It's been turned into something that's part of domestic legislation. And that's why the bill provides at the moment that that's not the case, and that the UK courts aren't simply given this very alien power to consider the validity of the EU regulation, which would involve them doing a whole new and rather artificial sort of exercise. But again, that's just a choice that you have to make. That's part of the mechanics of transferring EU legislation into domestic legislation. You can't avoid that choice, and the bill resolves it in that way for those sorts of reasons. You also get into related questions about how you interpret the EU regulation. What do you do with it? What tools do you use for its interpretation? What regard do you have to the way it's been interpreted so far? Bearing in mind, again, there's competing principles. On the one hand, you're trying to achieve certainty. People who've relied on a particular interpretation of the regulation over the years are entitled to assume that it will continue. On the other hand, again, it's been turned into something else. The reason the regulation was originally adopted was to remove barriers in the internal market. That's no longer a directly relevant consideration when considering what it means as part of domestic law. So what do you do? And the way that the bill resolves that dilemma is to make a series of legislative choices. As I say, we were part of the technical process within government of considering the implications, advising ministers on those implications. And the bill tries to achieve that quite delicate balance of preserving people's expectations, preserving what everyone knew about how that law worked up to exit day, but thereafter putting in place principles and processes, I think we'll hear more about this later today, about how you go about interpreting it in the new and different context, because something has changed on exit day. Again, in good faith, you need to grapple with these issues. You need to get off the fence one way or the other. There is no way of resolving these sorts of issues that doesn't create further dilemmas. And the bill, in the form that it's been introduced and the form that got its second reading yesterday, resolves these in a way that struck the right balance between these competing interests. It could have been done differently. This was the mechanism that was chosen, but the choices are unavoidable. And then you get to the powers that are needed. Primarily the Clause 7 power that's been spoken about so much is needed in order to batter this domesticated legislation into shape and to try to deal with it. And I hope it's relatively uncontroversial that these powers are necessary, because when you carry out this exercise of putting the legislation into domestic law, as I say, it simply doesn't work on its face. And there's a whole sequence of detailed choices that have to be made. To go back to the squirrel racing regulation, decision 1, at the moment the regulation says that you have to notify the Commission of who the authorised regulator is in the United Kingdom. No point in leaving it as it is, because you send the notification and the Commission says, why are you bothering us with this piece of paper? Who are you? So you have to turn it into something else. Policy choices, that somebody else could be the Secretary of State, it could be a new body, it could be a new body that has to be set up and given powers and funding and so on. And betraying no secrets to say, these decisions, a whole host of these decisions, still need to be worked through and still need to be taken. So that's one part of the reason for needing the powers. We need to think through all of these details. Another part, frankly, is you just imagine the scale of the bill if all of these detailed technical choices were put on the face of the bill. Then you come to the second category, and this is a very significant aspect of why the power is needed. As the regulation stands, the United Kingdom automatically has to recognise every qualified squirrel racing referee in every other member state. And the reciprocity isn't automatically there. So this all depends, as so many things do, on all sorts of interlocking decisions. But we don't yet know whether the withdrawal agreement will include a provision saying that France, Germany, Denmark have to recognise UK squirrel racing referees. And so in the absence of that clarity, you have to make a choice. And the choice either way has consequences. On the one hand, if you don't recognise German, French, Danish squirrel racing referees, then come the next squirrel racing competition in London, you may not have enough referees because there may not be enough in the UK. Flip side, if you only recognise, if you allow the reciprocity to continue, then that has implications for people's willingness to train as squirrel racing referees in the United Kingdom. Those are policy choices. Those need to be made. Those are policy choices that are inevitably created by the process of exit, and they have to be resolved one way or the other. And there's a whole myriad of choices of that sort that can't be resolved on the face of the bill, and that depend on events that haven't happened yet, such as the shape of the withdrawal agreement. And we within government lawyers and officials throughout government are going to have to spend the year between royal assent and exit day sorting out all of these. Our rough estimates, this is going to take hundreds, perhaps more than 1,000 statutory instruments. This is a massive, massive undertaking. And when the people talk about the breadth of this power, I think we within government who have the task of drafting these instruments think, well, just simply doing that task that we need to do is going to take up quite enough of our time, thank you. There's going to be an industry of producing these statutory instruments over the period from 2018 to 2019 in order to resolve all of these questions in tandem with the continuing negotiations. So then you get to the breadth of the powers. And believe me, no one wants these powers to be any broader than they have to be. There was no one within government who thought, right, let's seize this opportunity to draft a hugely broad power that will allow us to do all sorts of things. We've been discussing this for a year within government, and you had to have an enormous amount of political acuity to realise what would happen when you introduce broad powers into the House. So we were carrying out the very difficult technical exercise of trying to craft these powers in a way that would allow them to meet the objective, but be no broader than they needed to be. And the reason the powers are in the form that they are is because we scratched our heads and we thought long and hard about how to craft these powers. And this was the best we could do. The powers have to achieve an enormous variety of things. And we considered all sorts of ways of narrowing them and all sorts of conditions and so on. The difficulty is some of those constraints that might seem straightforward prevent you from doing things which I think most people in the room would agree need to be done. It's not at all a straightforward exercise to do it, and we've been spending more than a year since the referendum trying to work out how to do it. And I should say, it's not an irrelevant consideration that you do want clarity in your powers as well. You want to be sure that the power is broad enough to achieve the objectives that you want to achieve, and that's in the interests of individuals and businesses as well. Because if you have to push at the edges of your varies and you're not quite sure whether what you're doing is legitimate, then that creates uncertainty and risk for businesses as well. So it's a legitimate consideration for government to think we need to have certainty that the powers are broad enough to do. But look, again, I think we have the government, officials who've been working on this have no monopoly on wisdom, and if people can come up with ways of narrowing the power that will still allow the things to be done that need to be done, then terrific. And part of the process we've been reading the blogs, we've been reading the articles, we've been looking at the publications, and we're eager to find ways of achieving this, and the parliamentary debate and the public debate will all be part of that. I just want to point out some quite important constraints that are already in the bill, and there's a danger that they get overlooked. The most important is that Clause 7.1 tells you what the power to make regulations is for. It's to prevent, remedy or mitigate deficiencies in retained EU law arising from the withdrawal of the UK from the EU. So that's a very important and, dare I suggest, slightly underplayed restriction on the power. because the power has to be in connection with deficiencies arising from withdrawal. Going back to what I called the easy category just now, health and safety, working time, all those sorts of things, they work. And there's no deficiency that's created in the way that they operate arising from the fact of withdrawal. And so this power could not be used to do any of those sorts of things. That would be ultra vires this power, because that would not be a deficiency arising from withdrawal. Then you get to the other category, the squirrel racing, the decisions about setting up bodies, the decisions about whether to recognise events happening in other member states. The power needs to be broad enough to allow those things to be done, bearing in mind that the statute book needs to be in good order by exit day. And it's really hard to define and to pin down precisely what the power might need to do, precisely what the limits of that power might need to be in order to make all of that work. The bill is crafted as it is, with the illustrative list in clause 7.2, which sets out some ways that the power might be used, because that was the best way, we thought, to illustrate the sorts of things that the power might be there for. And then you can preennate the usual principle that even though it's an illustrative list, you can't just add things to the list willy-nilly, and anything that goes beyond that list has to be in keeping with the spirit and intention of what's in the list. That, after a lot of head-scratching, was how we were trying to give a flavour of the sorts of decisions that need to be made in order to use this power. If we could have found a beautiful, crisp form of words that exactly pinned down what it was that the power was for, believe me, we would have grabbed it willingly and put it in the bill. No one wants these powers to be any broader than they need to do. And of course, there are all the other constraints that have been much spoken of. There's the list of exclusions from the power, tax raising and so on. There's the fact that it sunsets but can't be used beyond a certain time. All of these were an attempt to constrain it as much as they could. I'll finish in a moment, but I'll just say one other power that's been much criticised for its breadth is Clause 9, which is the power to implement the withdrawal agreement. Again, entirely recognise that it's a very broad power. The difficulty for us on a technical level is that this is a moving target. The power is to implement the withdrawal agreement. When this bill was introduced, which was just before the summer recess, negotiations were just starting. They're still going on. We still don't know what this withdrawal agreement is going to look like. And it's very hard to craft a more constrained power to implement an agreement that doesn't exist yet. Of course, we will return to this during passage of the bill and look at it, and as negotiations continue in parallel, things might become clearer. But again, no one wanted to create a massive Henry VIII power that would allow anything to be done. Simply, I ask you to put yourself in our shoes. When the bill was introduced just before the summer, it's not easy to think what you can do to constrain the power when the agreement that the power is there to implement doesn't yet exist. But of course, this is something that we'll return to. And finally, of course, there are all sorts of procedural things that can be done. And that's of particular interest to this audience in order to deal with all the statutory instruments and allow enhanced scrutiny. And reading all the interesting suggestions that are coming from all sorts of sources, including the Hansard Society and Parliament, of course, because this is in Parliament's gift to a large extent, we'll be debating all of these and considering all of them. I just say, as a humble technocrat within government, we look at our raft of hundreds, if not more than 1,000 of SIs that we need to draft and get through Parliament in order to make all these necessary technical changes. And that's why we, as the beasts of burden who are trying to make all of this happen, gulp a little bit, because there has to be a process that allows these regulations to go through within the timetable and at the speed that's necessary. So, of course, there are mechanisms. Parliament will be looking at it. There are all sorts of ideas, but this is just an enormous technical challenge, and one way or the other, we need to find a way of reconciling these competing interests. I'll wrap up there. I'll just say, again, that a lot of people have been working hugely hard on all of this. The lawyers I've been working with in government, the officials who are working on this in government, an incredible team who've been working flat out on this for a year, and were staying up late last night in order to support the second reading debate. And it's been a phenomenal task. And at a technical level, people are just doing their best to try to make this work. There's always a strange process with a bill, because we're all discussing it internally, we're kicking around drafts. We all know from our internal discussions what we want the bill to achieve and what we think the bill has achieved. You make the bill public, and people who haven't been in part of those internal discussions then look at the draft and think, oh, hang on a second, what's that supposed to mean? And it's a very salutary and important part of the process to find out that actually a provision that we thought was entirely clear turns out to have different interpretations. That's why public debate's so important. That's why the parliamentary passage is going to be bumpy but interesting and a genuine opportunity to scrutinise and, if necessary, improve the bill. It's terrific that so many people are interested in this, and I hope we can continue these sorts of dialogues and conversations in order to work together, because ultimately it's in everyone's interests that we get this right.
Daniel, thank you so much. I'm extremely excited because it's only 10 o'clock and we've had squirrels and donkeys and ogres already, so I have high hopes for the rest of the day. I would bet, however, that you're probably the speaker that uses the word uncontroversial for most today. And just picking up on one thing you said, which was that there is tremendous interest in this. I can testify to that. One of the projects that we're funding is a project for a citizens' assembly that brings together 50 members of the public chosen to be representative of the British public by Ipsos Mori, and they had their first meeting last weekend in Manchester. So these 50 people were locked away in a hotel talking about Brexit, poor souls, for 2 full days. And a couple of times these sort of ordinary members of the public said, I'm a bit concerned about this Henry VIII stuff. What's all that about? So, I mean, we are at a moment where people are talking about politics in this country to an extent that wasn't the case before. Before I pass over to Shona, because I'm having a guilt trip, let me just mention our partners with this event today, who are the Welsh Governance Centre at the University of Cardiff, that do fantastic work on helping us understand what devolution means and what Brexit might mean for devolution, which I think are absolutely fundamental to this process. And secondly, you've all heard of the Hansard Society. I slightly dislike the Hansard Society because they took Bridget from us. But apart from that, I should say that they are the place to go to understand the role of Parliament. And their recent paper on how you can improve the withdrawal bill and ways in which you can improve scrutiny, I thought was a very, very good contribution to the debate. Without further ado, Shona, I'll pass over to you.
Well, thank you very much indeed for the invitation to come and speak here today. And it's a really marvellous opportunity to respond to a person who has had a chance to be involved in the drafting of this bill. And the timing, of course, is wonderful. I was up quite late watching the debates last night, as I'm sure many people were. Which were, depending on which reports you read today, either mind-numbingly boring or the most crucial debates in the past 100 years. Well, I found it very interesting what you were saying about your role in crafting and drafting and being involved in this bill. I'm sure lots of people have been working extremely hard. Many years ago, I was briefly a civil servant in what was the Lord Chancellor's department, working on the Civil Justice Review. I know just how hard civil servants work, and particularly in the run-up to a bill, the sleepless nights that can be involved. I don't doubt the good faith of those involved in drafting this extremely difficult piece of legislation. All I can say is that I'm glad I'm not a civil servant right now. I'm glad I'm an academic. And I haven't just specialised in public law and public law of the European Union, but for many years I've also taught jurisprudence. And for many years I taught jurisprudence in Oxford, and we had many, many debates about the nature of law. What is law? Is it moral? Is it political? And while I reject the view that law is politics, the critical legal studies view, I do believe that it's very difficult, if not impossible, to take a neutral approach to law and to say, well, this is technical. We're dealing with the technicalities here. There are choices that have to be made, but we're just doing this from a neutral legal perspective. I think particularly in the context of the British Constitution, which rests on so many political conventions, then law inevitably becomes political. Just saying that it isn't, I think, is itself a particular, perhaps political stance. So perhaps you won't be surprised to hear that my comments on the bill as far as it goes will not be neutral. I do see it as highly controversial. And quite frankly, I would number myself among those who think that the bill shouldn't have gone beyond its second reading. I quite appreciate everything that you've said. Put yourself in our shoes, the difficulties of drafting this. I am sure it must have been incredibly hard to draft. I mean, over 40 years of EU membership, the mixedness of another system of law is really, really hard to deal with. It is complex. It is complicated. But I don't think this bill does justice to the task. I don't think that one is rejecting Brexit or the will of the people by pointing out the problems that exist with it. I think it would be much better if the government went away and took longer and came up with something else. Why not do that? Why are we so pressed for time when we have probably the most complicated drafting exercise in 100 or more years? Why not take more time? In a minute, I'm going to go and give a really sort of very broad brush, which will seem very superficial, I'm sure, analysis of a few of the issues that I see as most problematic with this bill. Others will later on pick up those and deal with them in much, much greater detail. But my basic point is this: I don't think the bill should have got beyond last night. It should have failed at this stage, gone back to the drawing board, and some of the points that will be talked about today should have been dealt with. I might not go as far as Chris Bryant, who I noticed last night said, this bill is utterly pernicious, it is dangerous, it's fundamentally un-British. I think it has at its heart a lie. And he complained of a dangerous spiral of autocracy and clauses that Erdogan, Maduro and Putin would be proud of. On the other hand, I would go along with Dominic Grieve, describing it as an astonishing monstrosity. And Mark Elliott, I read with great interest one of your commentaries. You described the bill as, to say it is Byzantine in nature would be to do a disservice to the Byzantine Empire. And this may be a quote you'll come up again with in greater detail later on. If this is, as many people describe it, the most important constitutional legislation of a generation, perhaps 100 years, I think it should be something that is more intelligible. And I don't think it should be something that can be dismissed as a mind-numbingly boring debate, the debates on the second reading, when it concerns something as important as the transfer of power from Parliament to the executive. Okay, so in my remaining less than 20 minutes, I just want to pick up on some of the highlights of the bill. And its three main tasks, I think, are pretty uncontroversial: to repeal the European Communities Act in Clause 1 of the bill, hence the former title Great Repeal Bill, but also to convert much of EU law into UK law, to be found in clauses 2 to 5, and thirdly, to provide for a process of repealing or amending, converted or retained, as it's called, ex-EU law by secondary legislation to make it fit for domestic purpose. And Clause 7 is of a special reference there. And all of this raises the task of how to balance the need for the UK to be ready to leave the EU against the imperative need for effective democratic scrutiny of that process. And I would add also, something that hasn't been mentioned yet, how to maintain the devolution settlement, and a nod here to our Welsh colleagues who have played a part in organising this conference, how to maintain the devolution settlement to the satisfaction of the Scots, Welsh and Northern Irish, given that a large part of EU law is devolved, and those nations are not taking kindly to a power grab if EU law is repatriated to Whitehall. Okay, well, moving on then, here are some of the main points that I'm just going to really just glaze over because that's all the time I have. It would have been simpler for me, at least, to set out areas where I have no concerns. And I think there are 7, and I'm not going to get through all of them now, but I'll just say what I think they are, maybe 8 actually. The first concerns problems with replicating former EU law. Secondly, problems with repairing former EU law, specifically the problem of delegated legislation and Henry VIII powers. Thirdly, the problem of Clause 9 and the Withdrawal Agreement, the Article 50 negotiations, the agreement that comes from that. How does that come to be incorporated into this bill? And these, I think, would respond to 3 main points that you made. I would also include as real problems, though, devolution and the omission of the Charter of Fundamental Rights, and problems with the transition deal, how that can be taken account of in this bill. There's also the problem with the status of the ECJ and the status of judicial opinions, and I'm certainly not going to have time to get onto that. So I'll be lucky if I cover 3 or 4 of these points in the time remaining. Okay, point number 1, preserving or replicating former EU law. Well, the early clauses of the Withdrawal Bill cover this matter, clauses 2 to 6, and there's a whole new category of retained EU law. And the purpose is to preserve the status quo in the immediate aftermath of Brexit. Terms such as a snapshot or a freeze frame of EU law as it stands on Brexit Day have been used. And the Withdrawal Bill seeks to achieve this by numerous deeming provisions. So there's not going to be an exhaustive list of all the EU law that's going to be transferred. Rather, a conceptual approach is taken, employing broad definitions to capture different types of EU law. So, for example, Clause 2 deals with EU-derived domestic legislation. That's EU law which has already been implemented by domestic legislation. An Act of Parliament, for example, and it will be saved and have effect in the same way it currently does. Clause 3 deals with direct EU legislation, and that's basically EU law that is directly effective or directly applicable, including EU regulations. That then becomes retained direct EU legislation. And the explanatory notes tell us, because right now all we have are the EU instruments, that it's the full English language text of this that will be the operative one. They will be republished by the Queen's printers. So the EU versions won't be authoritative. It will be a newly published UK version. Clause 4 is a sweeping up provision because it says any rights, powers, liabilities, obligations, restrictions, remedies, and procedures which are recognised and available on Brexit Day. So any directly effective law not covered in the previous clause will be swept up by that. So that could be a treaty provision, for example. And Clause 5 deals with exceptions, EU law that won't be retained. And very interesting from my perspective, as somebody who's very interested in EU human rights, is that the Charter of Fundamental Rights is not going to be retained, according to Clause 5.4. Also, we learn elsewhere that there will be no right to bring a cause of action for breaching general principles of law, which include fundamental rights, according to Schedule 1, Paragraph 3. So there is a lot to be said about the human rights dimension of this bill. And we're going to have a session later on today to cover that, because I'm not going to have time to talk about it. But I think it's extremely important. And I noticed that both Keir Starmer and Dominic Grieve had quite a lot to say about the omission of the Charter in the parliamentary debates, as indeed did others. So many things could be said about this first point, about the preservation of EU law. I'm just going to focus on one, though, which concerns EU law that will be domesticated by clauses 3 and 4. So the directly effective EU law that currently exists only by way of EU law. So an EU regulation, for example, it's directly applicable in the UK. We don't have a domestic piece of legislation. Indeed, we can't, because that's not permitted under EU law. How will these be categorised? What will their status be? Will they qualify as primary legislation or secondary legislation? This is going to be extremely important for litigation, for matters of judicial review, to the extent that such measures could be annulled in future. So that is a very, very important point. It's a rule of law point. It's a legal certainty point. If we don't know what the status of a huge tranche of UK legislation is going to be, then that hardly makes for legal certainty. So that's point number one. I'm sure we'll hear so much more about the preservation of EU law later on. Okay, point number two, repairing EU law. And this brings us on to delegated legislation and Henry VIII's powers. And this is perhaps the area where there has been the most debate, the most criticism of this bill. And I was very interested that you said that no one in government wants these powers to be broader than necessary. I'm sure that for those of you involved in government who drafted this, that is completely true. But listening to the debates and what has been written about this bill, the fact is that there is a lot of criticism about the scope of these powers. I'm just quoting something I read by Raphael Baer. He says, the bill assembles an edifice of regulations amounting to the biggest peacetime transfer of power from the legislature to the executive in living memory. MPs have been presented with a monster stitched together from arcane procedures traditionally used to adjust small fry rules. One way to achieve the same goal would be a bill suspending Parliament altogether, replacing it with a Supreme Revolutionary Council, issuing Brexit decrees. Elsewhere, somebody else said, well, take the German Enabling Act of 1933 of the Weimar Constitution, an amendment that gave the German cabinet, in effect Adolf Hitler, the power to enact laws without the involvement of the Reichstag. So here is an alternative perspective on what is going on here. And you mentioned Clause 7. Now, yes, it is a constraint. These powers under Clause 7 may only be used where the minister considers it appropriate to prevent, remedy, or mitigate any failure of retained EU law to operate effectively, or any other deficiency in retained EU law. Now, yes, this could be used for relatively uncontroversial matters, but these are very, very vague, potentially nearly limitless terms. For example, Dominic Grieve has said, well, it's one thing to say that a provision is inoperable. It's another to say that it's deficient, which is the wording used by the bill. And he said, frankly, I could find arguments to suggest that every single law in this country is deficient. I'm afraid these will have to be changed. So that is a problem, I think. The Henry VIII clauses are an even bigger problem, particularly as there are Henry VIII clauses in this bill which permit the amendment by regulation of the bill itself. Now, to describe these as Henry VIII clauses is not a compliment. Some people might admire Henry VIII, but for many he's a monster. An SNP MP said Henry VIII was a despot with no interest in democracy, whose Scotland and Wales were just places to be conquered and trampled on. So perhaps this isn't such a bad name for something this government is doing. Now, all of this would be less of a problem, the breadth of these powers, if the scrutiny provisions for them were more robust. And that is another problem that has been flagged up, that when these regulations are issued, how much control will Parliament have over them? We know, because David Davis has said, that there will be at least 800 to 1,000 of these regulations, which will be issued by ministers for the amending of former EU law to make it operable for the UK. The question is, what control will Parliament have over these? And we learn by a reading of the bill, Schedule 7, that most of them will be subject to the negative resolution procedure, which means Parliament will not have a great deal of control or say over these statutory instruments. It will have a minimal role in their scrutiny. Certain types, yes, must be approved by positive resolutions of both houses, including establishing new public authorities and transferring functions from EU bodies to UK bodies. But the list, I think, does not include abolishing existing rules and functions. So this is the problem, I think, and this is why so many MPs have described this, the combination of the provision for the powers, the ministerial powers, and the scrutiny provisions as a transfer of power from Parliament to the executive. It's a procedural labyrinth. If you're an MP assiduous to do your job really well, you will be spending an awful lot of time looking at these regulations, trying to figure out exactly what they do. It's been written that this calls to mind Arthur Dent in the opening chapter of The Hitchhiker's Guide to the Galaxy. Learning his house is to be demolished from a council notice that was displayed in a cellar with no lights, accessible by no stairs, in a locked filing cabinet, in a disused lavatory, behind a door with a sign saying, "Beware of the leopard." So that, from some perspectives, might be the magnitude of the task. On the other hand, if this is taken seriously, if this scrutiny is taken seriously, how are parliamentarians going to find the time? So there is this tension between efficiency, getting this bill and the secondary legislation complete as is necessary for the smooth Brexit that we all hear that we must have, and on the other hand, the need for democracy and effective scrutiny. From my perspective, the solution to that would be just to take longer with this and not go for an exit day in March 2019. But maybe that's something that can't be said right now. Okay, now I see that I am running out of time. I am going to say something very quickly about Clause 9, and I'm going to finish by talking about devolution. Clause 9 says that a minister of the Crown may, by regulations, make such provision as the minister considers appropriate for the purposes of implementing the withdrawal agreement, if the minister considers that such provisions should be enforced on or before exit day. Now, this is the withdrawal agreement that will be the outcome of Article 50 negotiations, and it's likely will have to be enforced before exit day, otherwise there will be a gap. But Clause 9 is hugely widely drawn, and it's not subject to enhanced scrutiny by Parliament. So what it means is a minister, just a minister, may, under this provision, bring the withdrawal agreement into effect. Why is this in the bill? Why not have separate legislation to deal with this? We don't know what will be in the withdrawal agreement. We don't even know if there's going to be one at this stage. This is premature. There should be separate legislation, I believe, for this. Okay, finally, I see time is marching on, and we will have a whole session on devolution this afternoon. But it's so easy to forget that the UK is made up of 4 different nations. as well as being an academic, I have for quite a while been a special legal advisor to the Scottish Parliament on their Brexit inquiry, although everything I say is said in a personal capacity today. But we shouldn't forget the very real impact on the devolved nations of the Withdrawal Bill. And many EU competences are devolved. And at present, devolved legislatures may not legislate contrary to EU law. However, Clause 11 of the Withdrawal Bill alters this restriction by amending the Devolution Acts to prevent devolved legislatures altering retained EU law, even if it falls within a devolved area. As a result, devolved institutions are deprived of powers that would have returned to them by default on withdrawal. Instead, those powers will accrue to UK-level institutions. Unsurprisingly, perhaps then, in a joint statement delivered on the day the Withdrawal Bill was published, the First Ministers Nicola Sturgeon and Carwyn Jones described the bill as a naked power grab, an attack on the founding principles of devolution. There has been an indication, at least, that the Holyrood Parliament will not give its legislative consent. Although the British government has said it will seek consent, Holyrood has said it will not be forthcoming. So what will happen? Will there be a constitutional crisis? Will the UK government press on ahead, ignoring the lack of consent? A big constitutional problem there. I was interested to see that Paul Craig had said in his notes of evidence that it can be assumed that the drafters of the bill were cognizant of the legislative schema concerning devolved administrations. It was therefore a conscious political choice. So we face this down the line as well, a problem. Okay, well, I'm going to stop there, but I just fear, apart from anything else, for the British Constitution and what will happen as a result of this bill.
Shona, thank you, and indeed thank you both for kicking off today so fantastically well. You've raised a load of general issues that we'll be able to take up in the sessions to come. I am going to abuse the chair, actually, and just ask you one question, which is, we've got a ticking clock with the Article 50 timetable. Where does the extra time come from that you want?
Well, for a start, I mean, the Article 50 could have been triggered later. It didn't have to be triggered when it was. Some might say that was from undue pressure put by the EU. Regardless, given that everybody is now acknowledging, including David Davis, this will be extraordinarily complex, more time would have been welcome. There is also the question of a transitional period and whether some of this might be remedied by a bit of a status quo in a transitional period, in which case there are other problems with the bill that I didn't come on with that seem to deny the possibility for a transitional period to work effectively, because it would deny the supremacy of EU law and of the European Court of Justice, which might have to be maintained in a transitional period. So another problem arises. But the government has had 12 months to work on this and to realise from its excellent civil servants just how complex. And believe me, this is not criticism of you in any way, but to realise just how complicated, as you have stressed, this is. And it is a great shame that it will be rushed through so quickly. And not a great deal of time devoted to the parliamentary debates, the point that was made, in comparison, for example, to the debates over the European Communities Act and Maastricht, the time allotted to them in committee especially.
Okay. Right, and what I'm going to do is I'm going to take 10 minutes worth of questions and then give our speakers essentially just about 5 to 6 minutes worth of answering, because we've got to move on to the next session. And I'm always slow when I chair. I'm determined to be on time today. So,
would you agree?
is there a? Can you hear at the back? Actually, do you mind standing up and just sort of shouting?
Would you agree that the Conservative government is a minority government, and since your claim that this is political, his law is political, that if, say, a few Conservatives got out, the wrong side of the bed in the morning, they could stop this legislation or any sort of excessive use of power. And the other thing is the government or this parliament using any law or provision that it didn't already have? It has the right to use these. It's always exercised these powers. And are they using anything new in this piece of legislation?
Yep, gentleman here.
Yeah, I've got a question for both, actually, which is strictly legal, which is in connection with paragraph 6 of Article 7 and paragraph 2, paragraph 3 of Section 9. Considering the wording in paragraph 2 of Article 9 about the ability to amend this Act by regulation, is it intended that this paragraph 2 will prevail over paragraph 3 of Section 9, which says that the regulations under this section may not impose reduced taxation, may not make retrospective provision, and so on? So why there's no connection between the two? Why it doesn't say, what is the actual interpretation there? Because it would be pretty damaging if eventually this subsection 2 is actually in the position to change the scope of paragraph 3 of Section 9 and of paragraph 6 of Section 7.
Fortunately, they both brought copies with them. Are there any more questions for now, or shall we... gentleman there.
Mr. Denman mentioned at the very beginning in talk about institutional matters as well as mechanisms, but I don't think we heard anything about institutional structures to deal with the whole transition.
Okay. Yeah.
Just a very quick question. Given the timetable on which we're now set, after listening to both of you this morning, is it possible to avoid a cliff edge?
Anyone else at the moment? Do you two want to make a start? And we might get a second round of questions in. Do you want to go?
Okay, shall I kick off? Not going to answer the first question about minority government. I'll leave that to you. On the second point, on the point about how the government has always had powers to do these things, I imagine you'll have plenty to say. Of course, it's for Parliament to decide what powers to give to ministers, and then ministers must exercise those powers within the constraints set out in the legislation. I'm not sure I can say much more than that, but I'm sure you'll have many things to say about that. On the point about the interaction between Clause 9.2 and Clause 9.3, Clause 9.2 says regulations under this section may make any provision that could be made by an Act, including modifying this Act. 3 says, but regulations under this section may not do various things, increase tax, be retrospective, impose criminal offences, and so on. The first point, of course, is that 3 is clearly a constraint on 2, so nothing done under 2 could do any of those things. I suppose your question is, could the power in Clause 9.2 be used to amend Clause 9.3 to remove those restrictions? I think the answer is pretty clearly no. That sort of bootstrapping can't be done using Henry VIII powers, however broad they may be. The courts have always been very clear that Henry VIII powers have to be construed narrowly. We've all learnt about some cases like Padfield in our constitutional law lectures. You can't use powers in order to undermine the purpose for which those powers were given. So, no, I don't think that would be possible.
But if you look drafting point, do you think it would be easier to refer to the fact that these acts other than section? Because of course, you cannot put this out to a judicial review. So there was a number of discussions about it. In terms of certainty, would it be more appropriate to define these acts except for?
Well, I mean, there are drafting points. It seems to me that's pretty clear. But regulations may do these things, but the regulations cannot do the following. That's a swashbuckling modern drafting style, and I think that seems to me to be pretty clear. Just take a moment to say a word about why that Henry VIII power is there, and why this power includes a provision to modify this Act. And in part, that deals with one of the points that you made, which is we don't know what the withdrawal agreement will do, and it may, again, I'm straying into political waters, so I say this entirely hypothetically, but it may involve some mechanisms such as preserving I'm not going to say any of the such as is, but it may involve reinstating some of the things that the bill removes from the European Communities Act, and therefore you need to be able to put them back in. That's why that's there. But of course, as I said, so much of this is unknown that it's very hard to confine this power at the moment. The question about institutional structures, I wasn't entirely sure what you had in mind.
Structure, you said.
In- yes.
You mentioned structures and mechanisms.
Do you mean within Parliament?
I do know, you didn't elaborate.
What did I say? Well, I was talking about two things. One is if there's existing preserved EU legislation that includes institutional provisions, such as a role for the Commission, then something needs to be done, and I think we agree about that. There's also the point about parliamentary scrutiny processes, where, of course, there are many things that could be done. As I say, a lot of that is within Parliament's gift, not the government's gift. And, of course, there's been much discussion, and will be discussion later today, about how that can be dealt with. The last question, can you avoid a cliff edge? Again, as I said, this bill is to a large extent designed to be policy neutral. It's designed to be available to deal with a wide range of outcomes. If, which we hope and expect that this won't be the situation, but if the UK were to leave the EU without a withdrawal agreement, then this bill is part of mitigating the consequences and ensuring that to the extent that it's within the UK's gift and to the extent that it's within Parliament's gift, you've preserved some of the legal order within the UK. Of course, you can't deal with it absolutely because a lot of things go beyond what the UK can do unilaterally. But this is part of the mechanism for making sure that in a range of circumstances, including that, steps have been taken as far as they can be to deal with the possible consequences.
Sure.
Okay. Right. Well, the first question concerning whether we have a minority government and certain Tories could stop this. Some Tories have been quite vociferous about what they take to be defects in the bill, but seem to be acting on the basis that these defects could be cured by amendments that are carried, rather than by rejecting the bill in its entirety at this stage. So I suspect it depends on what you think about the nature of the bill overall, how flawed it is. For many members of the opposition, the views seem to be the bill was so flawed that it just had to go away, it had to be started again from scratch. I don't think I said I believe that law is politics, but I don't necessarily believe that it can be totally neutral. And I did say that in the context of the British Constitution, very much of it is, of course, political. Is this government or parliament using any powers it didn't already have? Well, I suppose this is where the debate about the potential transfer of powers from Parliament to the executive, especially through the medium of Clause 7, becomes relevant, but that would have been achieved with existing powers. So the problem might be that we don't have very strong, entrenched, codified constitutional provisions that would stop that from happening. This has been a problem which the devolves have also recognised. We are not in a federal Britain, and they are not able to protect their position by assured legal rights and procedures. So that is one of the problems with the pragmatic, flexible British Constitution. Second question, on specific clauses in the withdrawal bill, and in particular paragraph 2 of clause 9. I think the thing I would say about that is my worry would be is that now we are continuing on, and obviously the amendments that are going to be made or carried even to this bill are going to be very important. To what extent could clause 9.2 be used to override any of those? I'm concerned about that. Question on the timetable and avoiding the cliff edge. Well, yes, I mean, it does depend on what is negotiated at the time of the withdrawal agreement and if it is possible. I mean, that would be one way of producing a cliff edge anyway, if we lack a withdrawal agreement. Yes, this bill could still be carried, but to what extent would it help if Britain crashes out of the EU without a withdrawal agreement and has to fall onto WTO terms? Then there would have to be even more activity, I think, than is foreseen by the use of ministerial powers in this bill. So I don't know where you'd stand there, but I'm not sure that this bill would adequately prepare you for that.
But presumably we need to distinguish between a legal cliff edge and an economic cliff edge there.
But even if it's an economic cliff edge, Britain crashes out and falls back onto WTO terms, you still have to make some legal provision for that. And an awful lot of EU law might not be applicable in terms of complying with single market regulations or not. So the situation is going to be different, and the use of those ministerial powers in Clause 7 is going to look a bit different, I think, if you have no agreement at all and are falling back on the WTO.
Are there any final questions? We've got about 2 minutes left. If we haven't, I suggest we...
You mentioned the colossal task facing you to get it all done by March 29, 2019. Also about the question of reciprocity, and do you switch off the rights of the school referees to do things? I enjoyed your illustration. Obviously, there are much more important ones, such as the rights, say, of the EU, Deutsche Bank, London branch to provide services to its customers and for their customers to continue to get those services. And that shouldn't be subject to the ministerial fiat on 3 weeks' notice that no one spots, because it's in Schengen's locked basement. It strikes me that the policy changes about whether reciprocity should be switched off and continued are things that can be dealt with at leisure after 2019, because there is no mischief in allowing the existing status quo to continue while there is a greater public and policy debate. I'm interested in your views on that.
Well, shall we let Shona go first this time, and then you can have the last word.
Okay, yes, in terms of reciprocity, I wouldn't just look at Deutsche Bank, but also other provisions in the area of freedom, security and justice, the European arrest warrant. As I see it right now, that seems to be wrapped up within Clause 9 as being part of the second stage of the Article 50 negotiations. And I would have thought Parliament would want to take a closer look at what is agreed on reciprocity when it comes to rights of individuals, particularly in the criminal law field. And as the bill now stands, it seems that a minister can simply put that agreement into effect without the need for very much scrutiny at all.
Yes, I mean, you're right that Clause 9 may be the appropriate vehicle for this. Again, we're trying to deal with overlapping possible circumstances, and it may be that the point about lopsided reciprocity doesn't arise if the withdrawal agreement preserves the reciprocity. But to take your point, could it be postponed? Why do you have to why couldn't you just preserve one-sided reciprocity and then deal with it afterwards? That may be appropriate in some circumstances, it may not be appropriate in others. It may be that in some circumstances real and immediate damage would be done by preserving reciprocity. There's a huge range of circumstances that need to be considered. And as I said, when we were going through this and trying to devise the powers, we were trying to anticipate every possible set of circumstances and come up with some constraint. And I think if you're putting in a provision in the bill that said you cannot deal with these sorts of problems, you must preserve sort of one-sided reciprocity regardless of whether the other side of it exists, could create all sorts of problems in all sorts of circumstances. You mentioned some of them. This would extend well beyond the sort of economic context. It would extend into criminal cooperation, goodness knows what. I think that's why the power needs to be there in order to allow those sorts of difficulties, fundamental deficiencies in the policy sense, to be anticipated and dealt with as far as possible.
I wasn't suggesting that you should be prohibited from doing it, but really the process for doing it could be the more normal legislative process.
In individual cases, that may be. I mean, as I say, I keep saying this, the bill is designed to create the framework to allow these powers to be exercised, and then, of course, that necessarily involves considering how you scrutinise the exercise of those powers, but the powers have to be defined in a way broad enough to allow precisely that sort of discretion. Will ministers decide to preserve the status quo and then come back and look at it in slower time, bearing in mind, of course, that the power is time limited in order precisely to deal with concerns that the power is too broad? Maybe that's the answer in some cases, maybe it isn't. I think there'd be real difficulties if the power precluded dealing with those sorts of problems from the outset. But yeah, this is all part of the process that will need to be gone through. And during the parliamentary passage of the bill, there'll be much discussion about scrutiny processes, about precisely those sorts of very difficult policy issues and how to keep Parliament involved in that process during the long road that's ahead of us.
Excellent. I'm afraid we have our own ticking clock and we've come to the end of this session. I'd like to thank you both, and particularly you, Daniel. I don't imagine for a moment you thought this was going to be easy, but for coming along and speaking to us. And if you could thank the speakers, we'll then just swap straight over and move on to the next session. Thank you both.